Why am I doing this webinar? This is a super important webinar, but I always like to share my why. So the reason is that I have a family. I have people that are aging. I have people in my life that have gotten sick, who have passed away, and I want to make sure that the problems that I've faced and others have faced are not replicated. So a lot of you, some of you are here, have worked with me before, and you know that about my story. But just to share with you how I work is, I kind of conflate the personal experience with the professional experience. So, in my life, what inspired me to become an estate planning attorney is my grandmother passed away without a will. Carol and I just had our oldest, Connor, and we saw all of the problems that came out of that, and the administration of her estate. How things, we learned some things that we would do differently. Of course, we wanted to do our own estate planning, and we did, and that kind of did launch, not kind of, it propelled us into this space. So I've been for the last at least, 10 years professionally, even longer than that, personally, in the space of estate planning and also trust administration or probate, which is the administration of your estate afterwards. And so I've seen how it goes well, I've seen how it goes wrong. And very recently, we're seeing it again. So my mother-in-law here, when I wear that pink Ren Spooner down there, that's my mother-in-law, Patty. She just passed away on October 11th. And so we're living through that right now. And some of you on this webinar, I know that you have recently lost loved ones too, and you have going through that yourselves. So, much sympathies all the way around for everybody. It's already tough enough to lose a loved one. Never mind now have to figure out a job and what you do. And so that really is the seedbed of this presentation, because I get asked a lot, of course, at work when I'm meeting with clients is, okay, how are my successor trustees going to know how to manage the trust or rule book? Or I have people who call up and say, hey, mom or dad just passed away. They had a trust. I don't know the first thing of what to do, or I've been trying to do it for the last few months and things haven't, I've hit a roadblock. So I need help. I wish there was a manual. And so I always get that a lot. Is there a checklist or a manual that you can give me to help me go through the next steps here? Because I haven't the foggiest. And this was, some of you are here, are our clients already. And so you were asking for this. And so I kind of finally listened. You wanted something, so we're providing it. We've done this webinar before in the past, but we have something a little different today. We have some goodies. And if you stick around to the end, I promise the goodies are going to be worth it. So you're going to get some goodies at the end. We are going to stick to time. We are slated to go no longer than an hour, but I want to leave the Q&A. So I'm going to really try to land this plane at 1:15 or 1:20, and then leaving 10 to 15 minutes for Q&A. Okay, and so by that point, we'll get to the goodie stage. And I'm saying goodies because yesterday was Halloween, and so we had a lot of treats in the household, a lot of goodies. I got my fair share of the dad tax, so I'm thinking about goodies. So there's going to be goodies for you. Just stick around. So this is what you're going to learn. So again, I'm Kevin Snyder, estate planning attorney, but I also handle, or my firm handles, trust administration and probate. So the other side of your estate plan. So when your estate plan needs to go into effect and be implemented, now we switch to the arena of administration. So you need to, then you go into trust administration, the implementation of your trust. And you, of course, named other people to carry that out for you. And so they're in charge. They're responsible for carrying out your wishes, whether we're talking about after death wishes for your memorial services, your funeral, whether you want to be buried or cremated, all the way to your financial wishes. You want people to receive something, to your legacy wishes. So that's why you've created the trust, and you've designated somebody else to be in charge, and that person is called a successor trustee. When they elevate to the role, they become the trustee. You are the trustee right now if you're here and you have a trust. Later, if you're incapacitated or you died, then your successor trustee will then become the trustee. You will no longer be the trustee. So what we're going to learn today, we're going to review a little bit more about the living trust, how it works, the role of a successor trustee, what it really means to be a successor trustee. It's important to know that job, right? Or we're assigning that job to somebody, or you've been assigned that job by somebody else, but yet you don't know what that job really entails. We're going to clear that up today. I have a to-do list and a not to do list. Super important. They're equally as important. So for a while, I would just say, here's the to do list, but you can't not have the not to do list, right? By omission, don't do it, but really let's spell that out because those are basically the common mistakes. So we're going to go over common mistakes. Don't do that. And I'm going to talk about the trustee handbook. So that's the goodie or one of the goodies. And we're going to talk a little bit more about that and how you can get that trustee handbook. So that's our roadmap for this conversation today. That's where we're headed. Yes, the disclaimer. So the little disclaimer hat on. I do want to keep my license so that I can keep helping people. And so the State Bar of California says that I have to give this disclaimer. And I'll go through fairly quickly. I won't do the Micro Machines guy or the voice on all of the commercials for prescription drugs. But I'll go through it quickly. This webinar does not establish an attorney-client relationship. I am talking about things you should know, but that doesn't independently establish an attorney-client relationship. Some of you are already clients. But those of you that aren't already clients, some of you might be here because you are a trustee or successor trustees of our clients. So we're not becoming your client yet. All right. So we're just giving you information. It's for educational purposes only, no legal advice. So it's only, this is only for California too, by the way. So if you're beaming in from Massachusetts, Nevada, Alaska, wherever, these laws are only pertaining to California for a trust in the state that's being administered in California. So you might be a successor trustee in one of those other states, but if your loved one, your mom or dad passed away in California and everything's in California, the trust is going to be administered most likely in California. So these are the laws you're going to need to know, even though you live in Florida or Massachusetts. So there's a little extra thing that you're going to need to know about that, about what jurisdiction to choose. But we're just going to talk about the fact that if you're on this webinar because somebody has named you to be a successor trustee, that person who's called the trustor or the grantor, they live in California, they have property in California, high likelihood that the trust is going to be administered in California and fall under California law after they pass away. And certainly if they're incapacitated, and the trusts all say that. So all our trusts say that this is going to be subject to California law. So don't take this and say, this for my trust, my estate in Florida, I should do this and that because Kevin said. Don't do that. Okay, you should consult with your own attorney. If you are a successor trustee and now you become a trustee and you're on this webinar because someone in your life who named you as a successor trustee just died or has become incapacitated, then we can talk. And if you'd like to, we'll talk a little bit more how that happens. But we can then help you, and you can hire us to be your lawyers, even if you live in Texas, Florida, any other state. And the person that drafted or created the trust has passed away here in California where they live, or they are here in California and maybe in assisted living, in-home care, and memory care. They no longer have cognitive abilities. So that's the disclaimer. So let's get to the first item. Let's review fairly quickly, all right? Because all of you on this call probably know what a revocable living trust is because you've either created one yourself, you reviewed it after you heard that you were selected as a successor trustee. So you've seen this trust, but just a little baseline here. A living trust is basically a document that says this is what I want to have happen with assets that are in my trust after I pass away, of course, and if I become incapacitated. So it's a box, if you will, or a bucket or container that is going to hold assets to be managed either by yourself, or then if you become incapacitated, then you have your successor trustee do it. If you pass away, your successor trustee is now holding this box or container and has to follow a set of rules. We call that the trust manual. And that manual says this is what Kevin wanted to be done in his trust. In Kevin's revocable living trust, this is what he wanted to have done with these assets. Now go ahead and do them. So a trust is implemented by trustees. So that's the person or persons that are serving. They are trustees. You might be in the, you're on the on deck circle right now as successor trustees if you're on this webinar, and because you've been named successor trustees. Everyone else, your people that you want to take over for you, they're on the on deck circle, right? So, and they're going to manage this trust that you've been managing and the assets in it. So why is that important? Well, we got to make sure that we understand what that trust manual says. Is it consistent with your wishes? We got to make sure that the assets are actually in the trust. Joke, like, why would you create a trust and not fill it? Happens every day. So variety of reasons why. You've forgotten to do it, you thought you did it and didn't really do it, thought somebody else was doing it and they didn't do it, or it was moved, like with a refinance. We see that a lot, where the lending company moves the house out of the trust to do all the paperwork, secure the note against the trust, record it, and they don't put it back in the trust, either because that's not their part of their practice and they say you have to do it and that wasn't clear, or you just haven't got around to it, or they say they're going to do it and someone messes up on their end. Well, expensive mess up or oversight, because now the house is not in the trust and it's not controlled by the trust manual, and then we might have to get the probate court involved. So where do we go from here? Well, I almost forgot. Here's this visually what the trust is, right? So your living trust is that treasure chest there that's open. You are the beneficiary during your lifetime. You can have access to all of your riches, your assets. After you pass away, then it goes down to your beneficiaries, whether that's your surviving spouse or children, grandchildren, so on and so forth. What we put in there typically is all of your real property, your house and other real estate that you might own, businesses, so certificates that you have, shareholder certificates, you're a member in an LLC, that all goes in your trust. Of course, money, whether it's in the form of cash in a bank, whether it's financial stock investments, your brokerage account, it's sometimes annuities, sometimes not annuities, never your IRAs or Roth IRAs or 401ks. We don't put those in your revocable trust. If you have sizable amounts, and some of you may have worked with us, we've created a separate trust called a standalone trust that's revocable during your lifetime, becomes irrevocable at your death, and that trust is designated as your beneficiary. So you put that trust as a beneficiary, not a person. And the reason you might do that, now maybe you have a $500,000 of savings in there, $1 million, some people I talk to, or 2 million. It's not that uncommon. You have two spouses that both worked, they did good saving, and that's quickly ramped up now that they're in their 60s. It's now into late 60s, early 70s. Now that's 2 million. Now they're retiring with $1 million each in a 401k that they roll over into an IRA. Then what happens? So we want to protect that. You're probably your second largest asset next to your house. Some people it's their largest asset. So we have to look, how do we protect that? So that will be in its own separate trust, and it's not really in it. It just becomes the beneficiary of it. That's why your financial advisor, your CPA is going to freak out if you tell them, "Oh, my lawyer, or I heard Kevin, the estate planning attorney, say that you can put a retirement asset into a special retirement trust." No, we designate the retirement trust as the beneficiary. Because if you try to retitle your 401k, your IRA, by saying such and such trust, the IRS is going to say, "Thank you, you just triggered a taxable event. Now pay us all the income taxes associated against that balance that you have in there." Of course, the larger the balance, the bigger the tax. We don't want to do that. So don't do any changing, by the way, rule of thumb, without running it by your CPA, your financial advisor, and your estate planning attorney. Okay, so that just means that during your lifetime, it's business as usual. Your revocable living trust. I always tell clients, right? It's not going to look and feel no different. It's going to look different on paper, but it's going to have a special impact on paper legally, but it's going to look and feel no different. You get to have access to your assets. You're in control of all of your assets because you are the trustee of your trust. So it matters not that your house is now owned by the trust. It matters not that your bank accounts, now the account holder is your trust. All right. So you're in charge. And of course, the revocable living trust is amendable, meaning you can change it. You can totally trash it. That's called revoking. So it's revocable. That's why we call it revocable. But that just means it's also changeable. And you can change a piece or the entire thing. You can keep the name of the trust and change everything out. That's called a restatement, like kind of doing a home remodel. A little bit of that going over here in the Snyder household. So the trust kind of is just like this one, a revocable living trust is just a standby device. It's like, okay, we got the manual, it's ready to go when life happens. And these events happen that we want to not happen, but we know are going to happen. We just hope it's not soon. So our death or incapacity. So remember, I mentioned the on deck circle. So now your successor trustees are sitting there in the on deck circle. Now what happens? Something's happened to you, right? You've passed away, or you are fallen down, hitting your head. You're in a coma. You have been in a car accident. You had a brain aneurysm. You now have been progressing towards on dementia. Now you've reached the point where you can't make decisions to care for yourself. You have some sort of psychosis. You're clinically depressed and maybe you attempt to take your life. These are all situations in which something happens to you and for which you have people in the on deck circle. So then they need to come to the rescue. So they're jumping out of the on deck circle, jumping in, saying, put me in, coach. Let me get in to help you, rescue you from this bad situation. So number one, the situation where you haven't died, and that gets overlooked a lot because we think, well, just one day we're going to die, and that happens to people, sadly or tragically, or sometimes it is just old age, and the person's lived a great life and they're in their late 90s and peacefully passes away in their sleep. That's kind of the ideal. Everyone hopes it's that way. Not painful, it's painless. Your family is certainly sad, but it is understood because you're older. That is going to happen, and you had a great life, right? So that's the best way to go. Hopefully, that can all happen to us, but statistically, it's not, sadly. So we need to plan for that event. And some things that will happen before we die is that we're going to get sick or injured and not die, right? But we're not going to be able to care for ourselves. And the older we get, the statistics are against us. And so it's more likely than maybe when we were younger, although when it comes to dementia, of course. Of course, everything else, car accidents, brain aneurysm, heart arrhythmia, even if it's not necessarily a heart attack. And these are all things that even people in their 20s happen to them. I unfortunately know of a college student who's 22 who went to Modern Day, and he went off to school sophomore year, and his heart stopped. No history of heart disease, wasn't a heart attack. It's just his heart electrical wires got crossed and it stopped beating, and he ended up being on life support and dying afterwards. And that was about 7 years ago. And so since then, we've seen a lot of advocacy around AED devices to shock, somebody in that situation. And that would have saved his life, sadly, had that been accessible. So then that person was 22. Terry Schiavo was 26 when she had a stroke, basically, and lost oxygen to her brain. And when they finally revived her, she was brain dead. And that led to a very long fight all the way through the Supreme Court of whether or not she should be withdrawn from life support. She was 26. So there's a lot of stories about young people and things happening to them that you wouldn't think that would happen to them until they were older. But we hear it all the time, the car accident that takes a young person out and how tragic, or all the young people that sadly die during mass shootings, very tragic, or some other domestic violence situation. So can happen to somebody who's younger, it happened to you, and dementia is being recognized a lot earlier. So earlier onset of dementia can happen in your in your late 30s, in your 40s, and certainly now 50s is a little bit more common, unfortunately, but it's true. So we have to be prepared and plan for incapacity. That's what the successor trustee is there for. And then they're going to manage your assets while you're incapacitated. So they're going to pay your bills. They're going to make sure that all the caregivers you need are going to be paid for. Perhaps if you have minors, you're a parent with young children, they're going to make sure that your young kids can have their expenses paid for, school, medical, uh, keeping a roof over their head. Of course, help your spouse. That's for the young family. For older individuals, it's going to, with the fixed income, now they're managing assets to make sure that they're taking care of you and your spouse. Or if you're a widower, just you. Or you're single, just you. And so they're in charge of doing that, paying your taxes, the whole bill. So you're going to want someone in there that you trust, who's available, who's responsible, um, can be a good mediator, and is going to get things done. So getting things done, though, is not just, all right, let me pull out the manual and take a look at what does the manual say, and I'm going to follow that. This is the trap that people fall in, because there is a secret menu. So who here has been in and out? Silly question, right? We're in Southern California, where In-N-Out was founded, started in 1949. Fun fact, by a couple with the last name Snyder. Now, I wish I was related. And I guess I can't say I'm not, because I haven't deep dived into the genealogical tree or done any of the DNA testing. So maybe there is a connection, and maybe I should do that now that I'm talking about it. In any event, fun fact, they're the Snyders. I don't think we're related, but they're really smart, and they made this great burger that I so love. So I'm a double grilled onions guy. Although I have tried the raw onions, totally good with a raw onion, because that's what they have in the picture, right? So why not try it? Anyhow, so the secret menu is important because there's a whole list of things that have to be done other than what's in the trust manual. Your trust. Now your trust, you're like, are you kidding me? The trust, Kevin, that you guys put together, that's pretty sizable. That's like 100 pages, 95 pages. You're telling me that in that document, there's more, that isn't enough? And I'm telling you, yes, that's true, because the secret menu is the California probate code that's going to list all the rules and the deadlines and the duties that your successor trustee has to follow. So they got to know the California probate code. They don't have to be a lawyer themselves. They don't have to even read the code, although they're responsible to know it. They'd be best at a minimum hire somebody that is an expert in the area that knows it, like a lawyer that handles trust administration or probate. They're going to want to look for the guidance of the professional, because they have a fiduciary duty. So the fiduciary duty is on the secret menu. California law and federal law describe what a fiduciary is and what the role and responsibility is. So that all controls as to what you have to do, what your responsibility is, what you cannot do, and what happens to you if you mess this all up. So just a little foreshadowing is there could be a lawsuit to kick you out of being a trustee, or to kick the trustee out. And the lawsuit also comes with damages and attorney's fees. So you want to make sure that you understand the secret menu. And what happens when there is a conflict between the trust and the law? Because I'm looking at the manual, and my loved one who put this together, my relative or my friend who put this together and left this to me, has had some specific terms in this, and it says no need to send an accounting. But there's a conflict there, as we learn with the law, is that you have a requirement on an annual basis to provide an accounting, and this says don't provide an accounting. So I'm not going to provide an accounting. Ooh, that's a bad idea. Now you just stepped in it big time. And the beneficiaries can come after you for breaching your fiduciary duty, because you should know better. You should know the law, that you should know this secret menu, and you should know that you should have to do it, even though the trust says don't do it. So this is a whole secret menu. This is where the biggest area where trustees that try to DIY it get into trouble. So I can't tell you how many times we've gotten a call, and it's a trustee that's trying to do things on their own, and it's been 2, 3, 6 months. We've even had a year or more where they've tried to do it on their own, and now they're hitting a roadblock somewhere, and they say, "Oh, I got to get this taken care of. I'm trying to sell the house. Title company is saying there's some problems, so I'm at risk of falling out of escrow. So I don't know the solution. Let me call a lawyer." And then they call us. We pick up the phone in a meeting, talking, and it's like, "Okay, what have you done since your parent passed away?" And they tell me, and they missed the secret menu. And so the reason why title companies having a problem is because a lot of stuff that happened that was supposed to happen didn't happen. And can we fix it within the 1 week, 2 week to close? No, of course not. So now the house falls out of escrow. And now we have to go back and clean up the mess. And hopefully we can do that. Sometimes we can't. It's too late. Or there becomes with it hefty fines, or now beneficiaries are mad and they've lawyered up, and then they're looking to come after the trustee. Like I mentioned, they can sue saying the trustee breached their fiduciary duty because they didn't follow the terms of the trust and they didn't follow the secret menu, the law. So that's really, really important. So the fiduciary duty is to the beneficiaries of the trust. The fiduciary duty is not to the person that passed away. So you say, "Oh, well, I am the successor trustee, so I owe my allegiances to my mom, dad, friend who passed away, who created this trust." No, your fiduciary duty is to manage that trust for the benefit of the beneficiaries established in that trust. So yes, that means following the rules of the trust. So of course, yes, they're the trustor created those rules. So in an indirect way, you're honoring that person, but your duty is to not to, for a deceased person, your duty is to a live person, the beneficiary. So that's interesting, right? Because that's what the beneficiaries are going to say is that you breached your duty to me when you didn't do these things you were supposed to do. So that's the first thing they're going to come after you for. And knowledge or lack of knowledge is not a defense. I didn't know about the secret menu. Too bad. Doesn't matter. Law doesn't care. Judge is not going to care. You had a duty to know about it. You had a duty to educate yourself. You should have known that you didn't know anything about administering a trust, and you should have got help, whether that's the estate attorney who does trust administration, whether that's a accounting firm, a CPA that has handled trust tax returns, the financial advisor to help you manage assets. You need all of those people when you are a trustee. If you don't and you try to do it all yourself, all you're doing is globbing on all sorts of liability. That target against you has just gotten super big, and you don't have to be a sniper to hit a headshot with that target. The beneficiaries are going to come after you somewhere along the line. Something is going to come up that makes them pause and say, what's happening? And then they're going to say, maybe I should talk to a lawyer. And once they talk to a lawyer, then that turns into the lawsuit. So we need to follow the secret menu. You need to work with somebody that understands the secret menu. The general duties of the successor trustee fall into three categories. So this fiduciary duty, kind of the timeline of what is happening. So we'll take the timeline of the trustor passing away. And this is, now there's no surviving trustors in this case, in this situation, this timeline. It's your parents, dad died 10 years ago, now mom passes away. Now mom and dad created this family trust, which is the same thing as a revocable living trust. It's a revocable trust, sometimes called a revocable living trust, family trust, or just revocable trust. And so mom and dad created it. Dad died 10 years ago. Now mom passed away and now has left the oldest child to be the successor trustee. Familiar story. So that person, that child, oldest son, has to then start to collect all of the assets and gain dominion over them, get control over them. So that's the house. Well, you better go get the key. You better change locks and have dominion over it. And a little helpful note: get some security cameras up. Super easy these days, right? Just go get a bunch of rings and put those cameras up so you can monitor that house, because unless you're living in that house, you don't know what's going on a day-to-day basis. And you can't just rely on the neighbors that are also kind-hearted. Oh, we're looking over the house, and can't rely on them. And certainly if you don't have the neighborhood watch, you need those cameras so you know what's going on, because people are going to find out that someone died at that address. How do they find out? Well, they just look at the obituaries, right? There are people who do this, or there's people in your own family. And this is the more likely situation that are going to try to come to the house and take things from the house. Oh, grandma would have wanted me to have this. Mom wanted me to have this. I'm just going to go grab it out of the garage, and they're going to try to take something. They're not going to be there to try to, rob the house, but they might start taking things from the house. And oftentimes it's these personal belongings, tangible items, jewelry that they attributed some personal relationship with. There's some connection to it emotionally, and they believe they want it, and they're trying to get it before it gets taken by somebody else. So this happens a lot. So just change the locks. So that's you securing the house. Now you got to secure the car. You got to go secure all the accounts. What accounts did mom and dad have, or Auntie Jane? What did she have? I don't have no idea. Got to go to the house and figure out and find records. Maybe she had everything in the computer, but what the heck's her password to the computer? These are all, of course, nods to making sure that you stay organized with your own trust, making sure you're working with a firm that's going to help you do that. So to complete your funding, so it's in the trust, that's great. But if nobody knows what you have in the trust, it's not helpful, or how to get access to it. So you want to make sure that you have something like a knockbox, NOK box. Check it out on the internet. It means next of kin. If you're into paper, the knockbox is great. My mom told me about the knockbox. I love the concept. You're getting everything centralized in a mobile container, like one of those little plastic file containers, and they have a whole system to help you get all your documents in order, because your death certificate is going to need information that's on your birth certificate, and so it's helpful to have the issuance of the death certificate, have that information readily available, because they're going to ask you for it, because they want to put it on the death certificate. Like, who were your parents? What were their names? What did they do? So what did you do for a living? So all that's important. So do get a knockbox. If you're not into paper, there's a digital version. We offer it to our clients, or we're going to be offering it to our clients. So our clients that are listening on this webinar, there's a little bit of a little teaser here. You're going to hear before the end of the year roll out something called EverPlan, and you guys get it. So if you're going to get the information to get it, if you want it, pay attention. And it's basically the digital version of the knockbox that I just said. So in a secure cloud account, you're going to have all this information in there for your successor trustees, your financial assets, deeds to property, your legal documents, healthcare documents. You're going to have a list of other personal items that you have. You're going to have the list of online accounts that you have: Facebook, Instagram, email, log into your computer, your phone. All of that's going to be saved, those passwords and everything, so that now your successor trustee knows what is there. And we put together a spreadsheet, which is going to be helpful with the asset inventory. Is a spreadsheet of this is what's there, and this is what's in the trust, it's not in the trust, what's maybe an insurance like property and casualty insurance, which will be important to know, a disability insurance, particularly if your trustee is acting because you haven't died. Well, now they need to know what they have to manage, of course. What are they dealing with? But certainly they would be helpful to know if there's some sort of disability insurance. If we're talking about you getting an accident, now you can't work. Does the work give you a disability insurance? Did work give you a accidental disability and death insurance? So if you died by accident, maybe there's some money there to collect: $500,000, $250,000, some places $1 million. So a lot of others might be $50,000. So this is going to be important though, because that's extra money that you are responsible for finding as the trustee. So your trustees are responsible for this. So if you want to have a beneficiary sue them for something, just leave it a mess, because then they can come after and say, hey, they did a poor job trying to find things. And we know that mom had this other account somewhere else, or we suspect that there was a life insurance policy somewhere, but we're not hearing about it. So you are now a successor trustee, has a responsibility of collecting and finding those things and doing due diligence. You can't just say, I took a peek and I have no idea, so it doesn't exist. No, you have to go out. Where did they bank? Talk to the banker. Do they have a safe deposit box? Where else have they banked? You have to be a little detective here, and the law is going to require it, because you have to think about being in front of a judge or a jury and being questioned. What did you do? You have to think like that. Well, here, judge, here, jury, this is exactly what I did. Here's all the 10 points of action steps that I took. That's due diligence. You're also going to have to pay debts and expenses and taxes. So you get to use the money from the trust to do that. So that could give you a little sigh of relief for a second, because here's a problem that successor trustees run into. The trustor dies, mom or dad passes away, friend, relative dies, and they don't have ready access to the trust because they don't know where the documents are, or they're waiting for the death certificate because they need the death certificate to show that now the successor trustee can elevate to the trustee because the last trustee died. Well, sometimes that death certificate takes a little bit of time and there's holdups. Maybe there was an investigation, there was an autopsy, or maybe that state where they died is slow in processing. Particularly, we saw this in COVID. I had a couple of situations where the trustors died in Hawaii, and you remember when Hawaii kind of opened up again in 2021, and everyone started going back. Well, this man sadly died, and it was towards the last days of their vacation. It was a mom and teenagers had to come back home to Hawaii without dad's body, and it took 3 months for Hawaii to process a certificate, the death certificate, and so the wife was blocked out of a lot of things where the accounts were just in husband's name, even though they had a trust, because it was just in the husband's name. Um, and there was a beneficiary, for example, she was the beneficiary, the pan death beneficiary, had to wait for this death certificate. Life insurance had to wait for the death certificate. Um, and actually things in trust, there wasn't much in trust, so she was out of money, and that was really really hard, a workaround. And guess who has to pay? You get now, you have the GoFundMe page, now you have your family GoFundMe, and other people are paying out of pocket, which might be that can happen, or your successor trustees are paying out of their pocket. Your kids are diving into their savings account, leveraging things on credit cards, to pay for the funeral, to pay for the property tax bill that just came in right before you died or right after you died. And there's a lot of upkeep and cost. They're paying out of pocket until they can get access to those trust assets. So another nod to, hey, make sure that your trust is properly funded. Don't just rely on, well, I think I did that back then. No, I want you now to confirm it. It was done. That's why we meet with our client care clients every year. And one of the big things we go over is that what's in the trust. Well, some people say, well, don't you think you would have known that because you did it when you did the planning? Well, yeah, you would think that, but sometimes life has a funny way of happening, right? So they're not in the trust. And then they're making a trust. I already talked about that. So we want to make sure that things are in the trust. So there's and accessible funds, and that's the biggest thing with life insurance. You got to wait for a death certificate. So we want to talk about some workarounds because our successor trustees might not be able to leverage savings. My parents died today. Hey, look, I got business. I got 3 kids. I got one at Mater Dei. I got the other ones that want to go to Mater Dei. I got bills to pay, man. I don't know, I don't have these deep pockets, right? Then a lot of people are in that situation. So your loved ones might not be able to just put it on a card to help out, or they might just financially stress them out and stretch them, because now they spent $10,000 or $20,000 out of pocket, funeral costs, and everything else. They had it. Now their kid or their spouse they have a life event and they need money. Well, they just spend it on your trust. Your trust isn't in a position to reimburse them yet. It will, but the money's held up. And last, they have to make distribution to the beneficiary following the terms of the trust and the secret menu. So all this is and the secret menu. And this is a majorly where we have some trip ups because trustees just look in the manual and say, okay, now it's time to do our distributions, a third, a third, a third, a fourth, a fourth, a fourth, or there's a third, a third, and then 1/8 to you, 50 you. There's different percentages, right? And they just start making those distributions. Or, hey, look, I'm a trustee who's a beneficiary. See this all the time. Name your kids as the trustees, and they're the beneficiaries. And so the one who's a trustee says, you know what, I kind of can use my some of my inheritance right away. I'll make a smaller distribution, and it'll be in advance, and I need it now. And he never, doesn't tell his siblings or her siblings that happened, either on purpose or just because by accident. I'm in charge. See, dogs don't like this situation I'm going to tell you about. So then the other ones find out later, like, hey, 6 months ago, you gave yourself $200,000. Why didn't you give us $200,000? We've just been politely waiting, and you're taking money from the trust. What else are you doing wrong? We want an audit. We want an accounting, and we're going to hire a lawyer. You're screwing us over. And so that's how it goes. Or if they have spouses that say, because you say, oh, it's my sibling, they're not doing anything, oh, George, Jane, they're, you know what, honey, this is what happened. And then the spouse is like, uh-huh, yeah, you know what's going on here, right, George? You know what's going on here, honey, Jane. I never liked your brother, your sister, or they're a little bit shady. I'm concerned. I've heard about this situation. You should go talk to a lawyer. And then that's how your trustee falls into the problems, because the beneficiaries have rights. Beneficiaries have rights. And you can't just, so this is what beneficiaries don't know, by the way. So if you're a beneficiary of a trust, and you most likely are, and this those of you attending this webinar, you have rights as a beneficiary. Guess what? The trustee is in charge, but they're not God. Well, they have authority like a general. They are not the president, right? They're not the highest. So we have to make sure that the beneficiaries know their rights, and we have to know the secret menu of when they get notified by major events. We have required to give them an inventory of assets. And by the way, the beneficiaries are entitled to those statements. What? The statements? Yeah. Bank statements, credit card statements, any statement involved with an asset, they are entitled to everything. So this can be a real problem, and especially when I said that I get contacted often by trustees that have been managing a trust, not one that we wrote, but they've been managing their parents' trust. The parents died a couple of years ago, and now they're hitting a snag. And I'm like, guess what? The beneficiaries can request statements all the way back the last 2 years. You've got to be kidding me. That's a lot of work. Well, guess what? They can. They're entitled to that. They're certainly entitled to an inventory of assets, and they're entitled to an accounting, as I already mentioned. The trust might not mention anything about accounting. The trust might say that the accounting can be waived, or there is no accounting required. Guess what? The law, the secret menu, says an accounting is required, at least on an annual basis. And there's a new law that says if you are a trustee because the trustor is become incapacitated, now you're serving as a trustee because your mom or dad has a dementia, guess what? You have to provide an annual accounting of your parents' assets to the beneficiaries, or whoever the trustor is. You have to provide that on an annual basis, even though the trust probably doesn't say that for incapacity. California law requires it. The secret menu requires it. So if you have been serving as a trustee because the trustor has been incapacitated, and that's why you're serving as a trustee, they're still alive, but you haven't been providing statements or annual accountings to your beneficiaries and telling them, hey, here's an accounting, then you have a big target on you because you're not following the California law. This is a law as of 2021. So it's been on the books for almost 4 years. So you're a walking liability, easy target for a beneficiary who goes to a lawyer, and their trust administration attorney or estate and trust litigation attorney, they're going to come after you. You're going to get a nasty gram in the mail, a demand letter saying produce these things. And it's going to be a lot of work because you have to go back, and in some cases you might not be able to access things. And certainly if it's bank statements, you're limited usually a year and a half online. Now you're going to have to contact the bank to get the hard copies, and they only keep the hard copies for 5 to 7 years. Beyond that, they shred them. So you can be up, a real creek here, like the show, if you're not doing your job. So you have to do an accounting unless it's waived, and there's an allowance for it being waived. Now, but what does that mean? You got to talk to a professional to make sure that you're getting the waiver done correctly. It's not just everyone signs this piece of paper and it's all good. There's a special way to do it right, because you don't want a beneficiary saying, I had no idea what it meant when I was waiving my right to an accounting. The last is timely distributions. Another area where people get tripped up is the law, real gray. That's the law. It says a reasonable time. Distributions have to be made in a reasonable time. So sometimes trustee says, I'm just going to do it in my time. Either they say that on purpose, or it's just by accident, my time. I'm going to get around to it when I get around to it. I have a busy life. I got my work. I got my family. I'll do a little bit at a time over the weekends, and eventually I get it done. And that might take me a year, 2 years, 2 years. But beneficiaries are going to have to wait because I'm doing all the work. Well, it doesn't work that way. That might fall into the realm of unreasonable, and the beneficiaries can come after you because you didn't make timely distribution. Another trip up is trustees might say, well, we'll just keep everything in the trust, right? Mom and dad had a house that was, in a great area. I could think of the one, Balboa Island, maybe. It's up in Big Bear, Lake Tahoe. It's someplace or any other place where it's like, we can rent this out and we can get some passive income. Mom and dad, there's no mortgage. They paid it off, or the mortgage is so small, we can get rid of that. And now we can get some real good passive income. We'll just keep it in the trust. But the trust says upon mom and dad's death, everything gets divided a third, a third, a third outright, meaning no trust. And so the trustee's like, hey, look, guys, we're just going to keep it in the trust, mom and dad's trust. Well, mom and dad's trust legally doesn't exist anymore. All right. Even though the title says it's trust, you can't just keep it in the trust. You have to make those distributions. You have to, the bare minimum, carve up the deed a third, a third, a third in that situation. You can't just say, oh, it's not going to be owned by trust. That if you do that, you're walking into a big trap. Both the beneficiaries now, it could be a trap from a standpoint of they find out you're doing something, they want it, or they want out, they want to sell their portion. Like, yeah, it's in the trust, but it's not. It's theirs. To the fact that they died, and then their 1/3 goes by way of their estate, and then it's in probate, and now their family's mad at you because the 1/3 could have been put in their trust, but they didn't have it because you said, "Oh, we should just rent it in the trust." And they're going to come after you and sue you. And then guess what? The county's going to come after and sue you because the tax assessor is going to say, "Hey, buddy, you couldn't keep it in trust without telling us. You had to update us and let us know that mom or dad died." And you can't just keep it in trust so you can keep the low property tax because the name didn't change. You're required to let us know within 5 months, and there's special forms you got to fill out. And there might fall into an exception that you can claim, but the forms are due, and if not, you can get fined, and the fine could be as much as 10% of whatever the new tax would be, up to $10,000 if you did so by accident because you just didn't know because you weren't working with a trust administration attorney, or up to $20,000 if you're like, who's going to know? I'm just going to do it my way, and you did it willfully. So this kind of, I've talked about the to-do list a lot in my conversation. You need to establish your authority as a trustee. This might mean, if it's incapacity, following the terms in the trust that say what incapacity means. And so this is a big, I can't even tell you how big of an area this is. If you have an older trust or any trust, we want to look at these terms and make sure that they're still consistent with reality. So we've been trending more to saying, hey, look, let's do one doctor, or we'll do a panel of people that like maybe it's your kids. If you have 3 kids, if a majority of them agree that you need assistance managing your financial life, then that's the trigger that pushes the successor trustee into trusteeship. And you have a backup that if you can show that you have capacity, then they don't get to do that. Why? Because it's hard to get a doctor's appointment. And if you have 2 doctor's letters, guess what? It's not going to be your primary physician. They're going to refer you to a neuropsych or a psychologist. Or I mean, a neuropsychologist or a neurologist. They're going to refer that out. So it's going to be much harder to get these letters, and that just means more wait time for your trustees to step in and help you. And you pick them to help you, and so then they can't do stuff, and then bad things happen to you because you aren't able to manage. And you don't want your son or daughter to just they have access to the bank account and they can do things. They know my login. They can do that. Well, if the bank finds out about it, guess what? They're committing a crime, a federal crime, and they could do federal prison because while they might have the authority from you, they don't have the legal authority without any establishment of it. And it might be difficult to get that from you at verbally later. The bank is going to look like somebody's just going in there. We don't care if it's son or daughter. Sons and daughters defraud their parents every day, or their loved ones every day, their neighbors every day. So we want to make sure that you have the actual authority. It says you need 2 doctor's letters. Do you have 2 doctor's letters? No. Well, then you had no authority to go into your parents' account and move that money around. And by the way, you moved it out of the account and that was illegal. And then you're in a world of hurt. You need to lock up the assets I mentioned, establish a relationship with any co-trustees. And sometimes this happens. We discourage co-trustees because group projects are hard enough in school. Group projects, when we're talking about your trust, that's going to be even more difficult. Why? Because we have our own opinions. We have our own viewpoints. And to have more than one person on a job could, the bare minimum, just stall things, never mind lead to fighting and litigation. So if the kids are all right, preserve the harmony. name one as a trustee at a time, or better yet, look at a professional fiduciary. Then your kids don't have to. You don't have to start pulling names from. Oh, I think Bob down the street. He's a great guy. I've had beers with him for years. He knows me. I'm going to give him this job. Or my good friend. I'm going to give him that job. He's responsible. Guess what? That friend's going to learn to hate you, dislike you incredibly later because it's such a big job. They don't have time for their own life, never mind trying to be a trustee for your trust, especially if you're incapacitated and haven't died. It's a bigger job. Or you pass away now, they have to deal with your family dynamics, never mind the trust assets and the work, and they're a target for lawsuits. So, geez, no good deed goes unpunished. Thank you, Kevin, so much sarcasm, for making me the trustee. But if you have a co-trustee here, be friendly, and from the get-go, you need to work together. The last thing that you need is co-trustees fighting or one coming after you. We see that sometimes, that brother, sister, they don't live next to each other. They didn't have really a relationship. That's a seedbed for litigation right there, because each trustee is entitled to their own attorney. So that's that you should know then. And that's okay if they each get a lawyer. Sometimes this helps them work together. But if they get the wrong lawyer who just wants to fight with everybody, then you can end up in litigation. And the only reason why they're going to go to a lawyer is because they don't like something that you said or what you're doing, or the appearance of what you are doing or not doing. So be transparent with them, make that connection early with them, and then talk about what you're going to do this, what you're going to do that. Divide up division of labor, because then you don't want a situation where one person's doing all the work and resents the other co-trustee that's not, because they didn't talk about it. But be mindful, you can delegate jobs, but you can't delegate liability. So you got to be looking over the shoulder of your co-trustee, because they screw up something, you're on the hook for it too. When it comes to disputes, resolve them quickly. Put the fire out right away. Trustees are beneficiaries. You don't want to ignore that, stick your head in the sand, or just pout or and put them on a timeout, because during that time they're going to go to a lawyer, and then you're going to get the demand letter, nasty gram, and that's could follow to a lawsuit. So you can seek mediation. You can go to the court proactively and say, we need some help in mediating this. There are lawyers out there, other and non-lawyers, that do mediation and trust administration. That's a great way to kind of mediate if you're at an impasse, you can't do it yourself. And then get your professionals, like I mentioned. You need them. If you don't get them, you can be deemed to breach the fiduciary duty. Even if you're in these areas, you are a lawyer, you're a financial advisor, you're an accountant, do not do it yourself. No DIY, and then when you distribute assets, you have to use agreement and have receipts of everything. It did happen. We got it. You agreed to this. You waived any objections to it, so that later they can't change their mind. For example, we decided on how we were going to divide the house. A beneficiary number one is going to get the house. Beneficiary number two, when they have a 50-50 split, was going to get the equivalent in cash of the house. Beneficiary number two later says, no, I really want the house. I see how much it appreciated. That was a raw deal. Well, you signed the agreement that you understood what you were getting into. Now you can't come challenge me years later. What not to do? Do not engage in self-dealing. You have that just means you're the trustee, and these are the do not do's, because these have happened and these are common mistakes. Oh, I'm going to buy the house from the trust because I'm a realtor and I think I could flip it and do better. No, that's self-dealing. You got to do it. It doesn't mean you can't get the house as a beneficiary, but you got to be really careful here. You can't invest in your own company. Oh, the trust, I'll take an advancement of my inheritance and put it into my business to kind of do some kickstart something, or do a capital call in my business. Can't do that. You can take your inheritance and do that, but you can't take the trust money and do that. So there's a distinction. It has to be your inheritance first, meaning that the trust has been settled, the money has you've gone through all the steps, and all the beneficiaries have signed off on you getting a certain amount, and now we've taken it, and now it becomes your inheritance. Then it's yours. You can do whatever you want. But it's not that, oh, it's this trust is still being administered, I'm going to take an advance of my inheritance to do these things that I otherwise might not be able to do if I don't do it now. That's self-dealing. Bad idea. Going to walk in the hot water. That goes along with conflicts of interest. So that would be like me trying to administer be the lawyer on some sort of trust in my family, right? That's a conflict of interest. I shouldn't do that. The biggest is unreasonable compensation. Most trusts will say a trustee gets reasonable compensation. Well, there's no dollar number there. What the heck does that mean? And so people make up their own numbers, and that they become sometimes just unreasonable with that because they don't know the rules surrounding what the money is. And this is a big area right now where you're seeing a lot of conflict between trustees and beneficiaries and lawsuits. Is at least if it's not the reason why, it's part of the reason or something they throw into the lawsuit. They're taking unreasonable compensation. The beneficiaries are looking at you saying, "Oh, wait a minute, Kevin drove a beat up Ford and now he's got a Lexus. I know he didn't change jobs. Where's the money coming from? And he hasn't been giving us those statements we've asked for. That looks fishy. I mean, he might be taking unreasonable compensation. So they're going to want to know. You're going to have to give them that accounting that's going to show how much you have. So you got to keep track. A trustee needs to bill time, essentially, unless the trust says you get a percentage, which you want to be careful if you're putting your trust together at a percentage because it's percentage per annum. So per year, the trustee gets as a salary. And it's usually like 1% is what we'll see in older trusts, 1%. That could be a lot if you have co-trustees because they each get 1%, not split unless there's special language that would said that. So you gotta, if you want to be compensated, because it's all generally waivable, if you want to be compensated, you got to keep your time, and you got to keep your time for professional services. And so, and you got to know what that professional services means. You got to know what you can keep time for or cannot, what you can bill for not, and what the price you can bill for. So you can get all that information working with a experienced state attorney to do that. Keeping bad records, say no more. Not communicating with beneficiaries, ghosting them or going dark, just is going to make them think you're doing something shady. Keeping poor records is going to, the judge is going to say, well, why didn't you keep better records? It's not that hard. All sorts of software you could use. You're going to hire an accountant really easy, and you didn't do that. So you are breaching your fiduciary duty. Now I'm going to remove you, and you're going to pay the attorney fees for the beneficiaries who had to come to me to remove you. Or because your poor records that, you lost something that had a consequence to an asset. Allow disagreements to go unresolved. So you got to be careful. Generally speaking, once everyone lawyers up, everyone loses. Nobody wins in court. Nobody. But sometimes, every once in a while, having a lawyer before litigation starts can be helpful if you have an unreasonable beneficiary or an unreasonable trustee. When they're getting their counsel, they are now reasonable because they are being educated. However, sometimes they get the bad apple lawyer who's just matching the beneficiary's mood and style and character, and they're not being a professional. They're just being a mouthpiece. And so that's why you really don't even want to be in that situation. We want to be transparent, and we want to educate early and often. Of course, doing things that the trust doesn't allow you to do, trying to modify the trust, doing so by agreement, like, oh, all the beneficiaries agree and we signed this paper, so therefore we can do this. No, that's going to be a problem. There are certain things you can do, but you have to go to court for those modifications. There's a whole process. All right, so as we trend to the end here, this is like a car. You're giving your trustee a nice car that you've kept well serviced during your lifetime, and you're handing the keys over to them when you become incapacitated or you die. So you want them to know how to drive the car. If they've never been trained on how to drive the car, they don't know how to drive a car, they're likely to crash it, right? And if you don't tell them how to service the car, then they're likely to not change the oil, they got to get the tires rotated, things happen, and the car is going to crash. So we want to give them the tools because we want them to be driving our car that we have kept in good condition over the years, and pass the keys to them and have them be able to drive this car, right? And drive it well. And so that means you have to do two things. You have to make sure you have the best estate plan, best trust, keep it updated. So you have to maintain your car and not just hand them a hunk of junk. And you have to be able to teach them in their lifetime, that's why we're having this webinar, how to drive that car. So they know how to drive it. They know where to find it. They know where to find the keys. They know how to drive it when they become the driver, when you've passed away or become incapacitated. So a little quick other tidbits. I mentioned the AB 2747 already. No, I didn't. I mentioned empty chair. which is if your trustor is incapacitated and you become the successor trustee, mom or dad's in memory care, you now have to provide an accounting every year to future beneficiaries. You're not beneficiaries yet, but in the future. So for example, that could be you and your siblings. You got to give your siblings an accounting every year. Goes into effect January 1st is AB 2747. If you have rental properties in a trust, or there's rental properties in a trust, you now not only have a fiduciary responsibility to the beneficiaries, you have a legal obligations to the tenants as a landlord, and there's going to be some conflicts there. And this is a very brand new law. So now, being a trustee, if there are rental properties in the trust, and that those properties are going to continue to be rented, is wider target. So now not only can the beneficiaries sue you, but now the tenants can sue you, not just the trust, but you as a trustee, because you are the landlord. So you're going to need some help to make sure that doesn't happen. And last, lions, tigers, and income tax traps. Oh my. Trusts earn money just like people. Assets generate income. We just talked about rentals. It could be that there's dividends in a stock portfolio. There's other ways that income could be earned, just simple, right? Interest on an account, a CD. So what happens with that income? It does get taxed. So, and it can get taxed on the highest bracket if we're not careful. So trusts are taxed at the highest bracket, like they are billionaires. And we don't want net income to be taxed at that rate. So we might have to push net income out to beneficiaries. Well, what, Kevin, that hurts my brain. What are you talking about? You're talking a different language. Exactly. You need to go work with an accountant, a CPA from day one that has experience doing trust administration. And guess what? If you work with a trust attorney like me and my team, we're going to put you in front of and bring onto our team a trusted advisor, a CPA we work with, because we want you to have that advice and know at the end of the year, hey, the trust earned this much income. If we don't make distributions of that income, then it's going to be X amount of tax. And if you're not paying attention, and the beneficiaries are, they can come after you because you didn't take an action of mitigating the tax. You fell asleep at the wheel, they're going to sue you. You cost them money because it eats into the other assets, which is their inheritance. So you got to know the income tax rules and how to mitigate the income tax. And the tax filings. A 1041 is a 1099 or K1 needs to be issued to beneficiaries. An estate tax, does an estate tax need to be return need to be filed? And a last little tidbit: does dad died, mom survived? Can mom take dad's unused exemption? Well, yes, she can, and she's going to want to. And you have to file an estate tax return to do that. But to claim portability, Kevin, these words, I don't understand them. Well, that's because you should be working with professionals. That's what I mean. So you don't want to have these missed opportunities wherein beneficiaries can say, you should have done that, and you didn't, and now that hurt us. So checklist, so goodies, top 10 things you should know as successor trustees. We will get you some goodies. So you're going to have that goodies, top 10 things you should know, and top 10, a checklist of what you should do immediately after someone has died. And so we get asked those questions all the time. So we're going to get those goodies to you. This is how we can help. You schedule a trust administration consultation with our office. That trust is going to be reviewed by me or my associate. And then we're going to meet with you, and so you can understand your role and go through the initial checklist. So you're going to have that appointment. We're going to give you the checklist, but you can get that checklist today for attending. But we give these people that call in that are trustees, we'll give them an immediate checklist so they get cracking on stuff they need to do. And we meet with them so they understand truly their role of what it means to be a trustee within that specific trust, because we reviewed the trust. Then beyond that, they can continue to hire us to help them be their consultant throughout the trust administration for the next 6, 9, 12 months. So we get to the offer. So you stuck around. Thank you for doing that. Hooray, hurrah, we're here. I know we didn't land the plane. Lots of stuff to cover. So if you stuck around, you get an extra special offer, and it's here. We have a successor trustee manual, and it goes into detail of what you should be doing. So and there's a lot more filler than what I shared with you today. And so we sell this manual for just about $200, $199, right? So you can buy this manual for us. So if you think someone would benefit from this, they can call us up and they can buy this for us, but they're going to buy it at $199. because you were here and to get this education, we're going to give you for $99, 50% off, limited time offer. Because we're not going to do that for long. You came here, you have until Friday, November 15th to get, that's the discount. For being here, you want the manual, $99 until Friday the 15th. You can easily scan this QR code and it'll take you to the link to pay the $99, and Laura will send you the Successor Trustee manual digitally. Okay, so just take a QR code picture right now, and you can do that, or copy and paste the link on the bottom. So thank you guys for coming on board today and sticking with and learning. Hopefully, there's some nuggets you took away from this. Remember the goodie bags. We're going to get you some of the goodies we talked about, the checklist, and really hope that you guys consider doing the offer with the manual, because that's a really great manual to have. It's been very helpful. We've had great feedback on it. Now, the upcoming events, I'd be remiss if Laura would say, why didn't you tell them? And here we have upcoming, really important. It's November, so we celebrate veterans in November. We celebrate them all year long. Very grateful for their service. I did not serve. My dad served. I talked to him this morning. We're talking about VA benefits. That's what this is going to be about. And Friday, November 22nd, we're going to be talking about how to get money for your loved one who is a veteran, or it was a spouse, or is a spouse of a veteran, surviving spouse. So call this Care Without the Cost, free support for veterans and their spouses. How can we get them money to help them pay for life? Because life is expensive, right? And they're on fixed incomes, but now they need caregiving. They're looking at getting in-home care or moving to a boarding care, assisted living. Dad served in Korea, but now he's in memory care. It's expensive. How do we pay for that? Guess what? The VA has something. Or a mom at home caring for dad, and he's struggling with Alzheimer's, Parkinson's, or what have you. We don't have a caregiver, but guess what? Mom can get some money from the VA under the VA caregiver program, which is something relatively new that I'm not even sure Laura knew about, because this is brand new stuff, and I have never presented on the VA caregiver program before, but I will on November 22nd. So if you want to look to help mom or dad get some money, or your loved one, veteran, aunt, uncle, your spouse, get some money to help them pay for their needs in life, not even caregivers, just needs in life. This is money that the VA will pay. Please come, invite your friends, invite people that would benefit from this. Friday, November 22nd. Same time, same place, here on Zoom. QR code, scan it, register now. Only registrants are going to be getting the invitation to come. Not open to the public, open to registrants. You can invite anybody from the public. Please invite everybody you know. This is super, super important and helpful, but you're not going to get the link if you didn't register. Have a great rest of your day, everybody. Thanks for showing up. Did I miss anything, Laura?
Nope, just a reminder that we will get you the recording and the slides after this event. And thank you all for being here.
Yeah, keep being amazing, everybody.